Hello students, welcome. Today we are here to understand the AMU judgment, that is Aligarh Muslim University judgment, which was passed on Friday by Supreme Court. Today we are going to understand what is the importance of this judgment based on UPSC. We are not going to get into the legality matter and intricacies that Supreme Court was talking about. We just have to look what is the specifics for UPSC, and in order to understand that, we are just going to look into three things, that is the history of AMU, the constitutional provisions, and the future updates that could happen. What will be the future of this judgment? So we are just going to look on that, and we will refer to the authentic sources like Lakshmikant and Spectrum while discussing this judgment. So here is an article on the judgment which says you don't have to read the whole article, you just have to follow the chronology and try to understand what all questions could be formed for UPSC. So in 1987, as you all know, Sir Syed Ahmad Khan formed Mohammedan Anglo-Oriental College for uplifting Muslims. In 1920, it was established in AMU 1920 Act under Central Universities Act. It was established under Central Universities Act as a educational institution under the central government itself. Again, in 1920 it was British Raj. In 1950, as India got independence, AMU was declared as national important institution. In 1950, it allowed non-Muslim members also to be the part of supreme governing body, which used to govern the day-to-day affairs of the AMU, how it will function and whatnot. In 1967, it eliminated the governing body and established an executive council, which will be the supreme body to govern AMU. When this was happening, the AMU was functioning autonomously, and an institution can function autonomously when it is declared as minority education institution, which AMU was not declared. A university can only function on its own without the guidance of government is when it is declared as minority education institution, which AMU was not declared. So in 1967, in Aziz Basha cases, this question was raised in Supreme Court, that is AMU a minority education or not? So in 1967, Supreme Court said that AMU cannot be classified as minority institution. So it was declared in 1967 that AMU is not a minority institution. So again, in 1981, what did Indira Gandhi do? Indira Gandhi government amended the AMU Act and established that AMU is a minority education institution. And in 2005, AMU also gave 50% reservation for Muslims in post-graduation for medical courses. So these two things declared that AMU is a minority education institution. In 2006, this case went to Allahabad High Court, which it said these two is unconstitutional. Why it is unconstitutional? Because in 1967, Supreme Court held that it is not a minority education. So you cannot bring all these changes. So against the Allahabad High Court judgment, the government went to Supreme Court. Not only the government but also Aligarh Muslim University. They both went to Supreme Court seeking that AMU should be declared as what? Minority education institution. So in 2019, this was referred to a 7-judge bench to to identify that if minority education institution status should be given to AMU or not. I hope the history is clear. Let's read about the history of Aligarh Muslim University. Let's take a look in the spectrum. What is given in spectrum? So in spectrum, it is given Sir Syed Ahmad Khan retired in 1976. He became a member of Imperial Legislative Council in 1978. His loyalty earned him knighthood in 1988. He wanted to reconcile. See, this is important. He wanted to reconcile Western education, scientific education, with the teaching of Quran which were to be interpreted in the light of contemporary rationalism and science, even though he held that Quran the ultimate authority. So what was Sir Syed Ahmad Khan point of view? He wanted that Muslims should not only learn about religious studies, their study should not be focused on religious aspect, but also in scientific aspects as well. And in order to implement this scientific aspect in Muslim, he introduced the concept of Aligarh Muslim University based on Oxford and Cambridge model. On the model of Oxford and Cambridge model, he established Aligarh Muslim University, which was destined to promote scientific temper and knowledge with religious studies as well to Muslims. Understood? So this was the thought process of Sir Syed Ahmad Khan to establish this Aligarh Muslim University. See, he opened schools in towns and book translated and started Mohammedan Anglo-Oriental College, later Aligarh Muslim University, in 1975. Understood? The Aligarh movement emerged as a liberal modern trend among Muslim intelligentsia based on Mohammedan Anglo-Oriental College, Aligarh. Okay? It aimed at spreading modern education among Indian Muslim without weakening the allegiance to the Islam. So both Islamic study and scientific study, both was the motive of establishing Aligarh Muslim University. So this was about the history. Now let's talk about the constitutional provisions that is given in Lakshmikant. What all articles are important in understanding these constitutional provisions of Aligarh Muslim University? First is Article 30 and then Article 15. These two articles are very important in order to understand what is this educational institutions and reservations. Let's see. First, let's talk about Article 30. See, Article 30 guarantees all minorities shall have the right to establish and administer educational institution of their choice. So they have the right to establish and administer the educational institutions. So Aligarh Muslim University Muslims have the right not only to establish but also to administer the educational institution like Aligarh Muslim University. Okay. What all is given? Thus, the protection under Article 30 is confined only to minorities. Okay, it is only defined to minorities, religious or linguistic. Okay, both religious and linguistic minorities both have the right to establish and administer their educational institution. The term minority, however, is not defined in the constitution at all. Okay, this is an important point to understand. Article 30 also talks about right of minority to impart education to the children of its own language. Minority education institutions are of three types. Okay, so this is important now. Minority education institutions are of three types. The first, recognition and aid both is given by the state to the institution. Second is they only get recognition and not the aid. And third, they neither get recognition nor the aid. Now, what will happen if an institution is getting recognition and aid or only recognition? So in such case, that is the first and second type case, the state has the power to regulate the syllabus, prescription, academic standards, sanitation, employment of teaching staffs, etc. So the states have some power over minority education institution if they are providing them aid or recognition or both. And should they have certain powers. But if they are not giving the recognition or aid, if the state is not giving the recognition or aid, then the institution is free to act on its own. It is free to act on its own. This issue is not the new one. It has been in Indian context for a very long time. So in 2007, Malang Syrian Catholic College case, Supreme Court has laid down certain principles, general principles relating to the establishment and administration of minority education institution. Okay, so this is important. Certain general principles have been laid down by Supreme Court to administer and establish what? Minority education institution. Okay, so let's see. To choose its governing body. So AMU had the choice of choosing their own governing, right? So if you remember, they allowed non-Muslim members also. They established executive council as well. So they had the power of having their own governing body. So they were acting in this way. Hence, they were starting to act as minority education institution. That is why Aziz Basha case took place in 1967. Yes or no, if you remember. In the second point, to appoint teaching staff. So this was also there, teaching staff, head ministers, and all the other things. So they gave 50% reservation to Muslims. They had the autonomy of appointing the teaching staff as well. So this was also done by AMU as well. To admit eligible students of their choice for reasonable fees and structures. Again, the reservation for 50% students. To use properties and assets to benefit of the institution. So these are certain things that a minority education institution can do, and this was done by AMU as well. Understood? So this was about Article 30. Now let's talk about Article 15. In Article 15, subclause 5 is important because it was mentioned here in this case. So what is Article 15 subclause B? It states the state is empowered to make special provision for advancement of any socially or educationally backward classes of citizen for scheduled caste or scheduled tribes regarding their admission educational institution, including private education institution, whether aided or unaided by the state, except the minority education institution. So what does this state? It states that every institution has to keep certain seats for SC and ST students other than minority education institutions. They are not required to keep seats reserved for SCs and ST students in minority education institution, but all the other institution has to keep. So this was the case, and the same thing the government is fighting for. What are they saying? They are saying Aligarh Muslim University has to give certain seats to SCs and STs as they are not minority education institutions as 1967 judgment. But Aligarh Muslim University is not giving the seats to SCs and ST students because they are stating that we are minority education institution. Understood? Now, this we have learned from Lakshmikant. Now, what should be done according to Supreme Court? What has Supreme Court said? What test it has said? It has given us a certain test in order to identify which institution should be declared as minority education institution and which is not. So, let me tell you one thing clearly. Supreme Court has not told that AMU is a minority education institution or not. It has just given a test. It has just laid down a test. And what is this test name? The name of the test is Pierce the Veil. The name of the test is Pierce the Veil. And this test is laid down by Supreme Court, and it has said the lower judge or a smaller bench now, with the help of this test, will decide if AMU is a minority education institution or not. Understood what has happened here? Now, what is this test all about? It is a twofold test. The Pierce of Veil is a twofold test. First is the establishment. It will talk about the origin or the genesis of the minority institution, the purpose of the establishment of the institution. So the bench first has to look, why was this institution established? What was the reason for its establishment? So this was the first thing that they have to trace, the origin. And the second is administration. Supreme Court has stated that not only minority institution has the right to administer the institution, minority education institution, anyone can manage the institution. Now, as we have learned on Article 30, in Article 30, which states that if the state is giving aid or recognition, state has certain power over the institution. Yes or no? Now, this is the thing the government is arguing, that we have given so many funds to AMU, and if we have given the funds to AMU, then we have the power to give certain guidelines as well, and the AMU cannot function as totally minority education institution. Yes or no? So these are the two things, that is pierce the veil, twofold test. Pierce the veil test is given by Supreme Court. Now the smaller bench now will see if the AMU is fulfilling the twofold criteria or not. So now we have done the history, we have done the constitutional provision. Let's look what is the future of this judgment. So before jumping into that, let's first talk about the difference between establishment and incorporation. So establishment, we will say if an institution is established when a minority has established the institution. If the minority has established the institution, then it will come into establishment and the institution will be declared as minority education institution. Understood? But if the institution or university is established through a law, by law, or through an act, then we will call it as an incorporation. In AMU case, it was not an establishment, rather an incorporation, because AMU Act of 1920, which created AMU under Central Universities Act. Hence, it will come under incorporation, not under establishment. So you have to learn about Central Universities Act, which talks about that central government has control over nationally important institutions on its reservation, on its syllabus, on its fees as well. So Central University Act becomes automatically important. So what key pointers you have to take from this judgment? First, you have to learn the history properly. You have to understand AMU history. You have to read about Sir Syed Ahmad Khan. You have to learn about constitutional provisions. You have to read thoroughly Article 30, Article 29, Article 31. You have to read Article 15. So these articles becomes important. You have to study piercing the veil. You have to study Central Universities Act. So these all points becomes important, as UPSC could ask question from these pointers only. You don't have to mug up all these legal terms and stories. You just have to be clear on what could be asked and what not. Hope this session was helpful, and you have any doubt or queries or questions or suggestions or corrections, you can comment below. Please like and do subscribe. Thank you.